Welcome to Patent Options Podcast, Securing Intellectual Property Strategies.
Hello, and welcome to Patent Options Podcast, Securing Intellectual Property Strategies with Jamie Sheridan, Patent and Trademark Attorney of Sheridan Law, LLC. I'm your host, Abigail Vaca, and today's episode is Beyond Google, the Importance of Professional Patent Searches. Thanks for joining me today.
Thank you, Abigail.
So, Jamie, what exactly is a patent search, and why is it such an important step in the patent application process?
So, a patent search is a review of a lot of patent attorneys would call prior art, generally patent publications, including granted U.S. patents and published U.S. patent applications that occur at 18 months from the earliest priority date of that application. Could also include a review of foreign patent applications and may include other prior art databases as well. A patent search is important in the application process because in order to obtain a patent, one's invention needs to be useful, it has to be novel, and it has to be non-obvious. With respect to the usefulness or utility, that generally isn't covered by the patent search. But when it comes to anticipation and obviousness, knowing what prior art a patent examiner may apply gives the applicant and the applicant's attorney, me, the ability to craft their claims in a manner that has a broad enough scope to be meaningful and have coverage, but not so broad that they read on the known prior art. So kind of in a nutshell, that's, the patent search process and kind of why, as a applicant, why you take that option. Again, it's not mandatory that one does a patent search, but in my experience, it helps speed up the process and save a lot of money in the long term.
So, a lot of inventors attempt patent searches on their own. What are the biggest risks or mistakes that people make when conducting their own search?
So I'm a big fan of inventors, doing their own patent search, primarily because if they start and they find what they're doing, then they don't need to call me and they save a lot of money and time and everything like that. But generally, what I see is an inventor starts doing their own search and they grow frustrated because they either find way too many related publications or they don't find any at all. They never find the happy medium of, the best 10, 20, 30, 40, or 50 references that are really relevant to what they're doing. It's a difficult process. It's mostly difficult because it's time consuming. Once somebody has the ability to navigate the process, then it takes less time and you reach the point of understanding the field in a much more efficient manner. But I'm a fan of people doing their own search. I'm just not a fan of when they think they've done it really well and they've only found a few things and they wait and they say we're not going to do any more searching. Then generally 2 or 3 years later we find out from the examiner where they found really close prior art and maybe we haven't dealt with that in the manner that we could earlier. What I see from the inventors is that when we find prior art that's relevant, they're able to provide more disclosure and more detail about why their invention is an improvement over the prior art that they review. When they don't review prior art, it's unknown, then later on, an inventor becomes frustrated because they have the detail to differentiate themselves. But unfortunately, once we file the patent application, we can't add new matter. And so it boxes us in with the maneuverability that we have to seek protection. So more knowledge earlier on is generally really helpful at a cost that upfront cost saves a lot of time and money later on during the patent prosecution of the application.
Well, you just made it clear that patent databases are vast and complex. How can the intricacies of these databases make it difficult for someone without that specialized knowledge to conduct a thorough search?
The title of the podcast, Beyond Google. Google Patents is a great place. I'll go there, and if I know a patent number, I'll put it in, and Google serves it up to quickly. If I use the Google interface and just put a few keywords in, I generally don't find, what I'm looking for. The US Patent and Trademark Office has a 7-step program that you can look and follow, and it's generally what any patent attorney or professional patent searcher is going to use some variation on that. I do personally. You go and it's an iterative process. You start searching with keywords, but you use an index to the manual of classification. You use the manual of classification itself. You search classes and subclasses of patents. And you take this road that goes through, and again, you have lots of options on how you search, and you start looking and you look at different ways, and you put yourself in the mind of the patent examiner, who how would they look at this invention, and how would they classify it? Would it be in one subclass or another subclass? Would it be in multiple subclasses for different reasons? And start looking at those, and there's electronic tools that can help us do that really quickly. But with the average, engineer or scientist that's doing his or her own search, they can go through the same process using tools that the patent office has online, or go to a patent depository library. Here in Colorado, it would be at the Denver Public Library. There's places where there's patent librarians that will help you do your search. What I find is, my clients that engage with me, they want to do their own search, but they can't do it in 2 to 4 hours like maybe I can do the search. With their knowledge and tools at their availability, it's going to take them, maybe 40 to 60 hours, and they still might not be confident that they've done the type of search that they really want to rely on. So that's where the differences between a scientist or an engineer doing a search compared to, a professional patent searcher, there's some difference there.
So, how does a professional patent search differ from that basic search online? What do professionals look for when assessing the patentability of an invention that a DIY search might miss?
So it's a whole iterative process of starting out and looking at the classes and subclasses that you want to search in, and then going through and searching those classes and subclasses, and then going back and for the relevant patents that are found, looking at what patents are cited by those patents and which patents that patent itself cites to. So it's a forward and backward search on the relevant patents that are found. So, using those tools, one's able to go and, relatively quickly look at, a universe of those patents. And then a lot of patent searchers will, for the relevant subclasses that are found, look at all of the patents in those subclasses and look to see if those are relevant or not, for further study and to be part of the search report that's put together that includes the keywords and classes and subclasses searched.
So, when doing a search, there's a big difference between finding patents for prior art and assessing the risk of infringement. How does a professional approach this, and why is it crucial to differentiate the two?
So, yeah, in terms of a patent search, there's different types of patent searches. There's the, patentability search, there's infringement searches, and there's which can be related to freedom to use, and there's also searches that relate to just a general landscape search. For most of my clients that are first coming to me, we're talking about a patentability search. So it could be the claims, but it's generally the written specification and the drawings and what those convey to someone having ordinary skill in the art as being part of the prior art. So we're comparing what's found in the prior art to what the inventor believes is the invention, what they believe is new and non obvious. So we really don't have to analyze the claims of the patents that are found, we actually are really looking at, it doesn't make a difference if it's a issued patent or a patent publication, because both of those documents, or even a another type of publication that's not a patent, we're looking at what does it disclose and teach, not what is claimed. So it's a much less detailed analysis, because we're not looking at patent claims and whether they're enforceable, and the metes and bounds of the claims and the identified patents. So so it's important to understand that aspect. With a infringement search, we're finding the relevant patents, but then we're actually culling the ones out that aren't issued, that have expired, or the claims include such detail that for the client, we're not going to have the limitations that are so specific that maybe some issued patents have that turn up in the search. With all of these searches, we're talking about a spectrum of effort and cost. And it's important to look at, with the different options again, which type of search makes sense, how the search is conducted, and how you map that out. With a patentability search for a new US patent, you're generally spending less than a couple $1,000s worth of time and effort onto. Unlike a litigation search, where it might be bet the company and there might be millions of dollars of damages, and maybe hundreds of thousands of dollars of attorney time in the litigation. That search, it may make sense to spend $20,000 or $30,000 on the search, and search in remote databases. There's been stories of sending a searcher to far off country and looking through file cabinets at a institution that are maybe not even in English language, and then obtaining that prior art, and using that as a basis for invalidating a third party's patent right. So there's a whole spectrum there and lots of different choices, but generally you want a high quality patentability search that gets you to that high confidence level of maybe like 90-95% theoretically, compared to a litigation search where you're going to want to get to 98-99%, and for some things want to get to 99.5%. You're going to spend tens of thousands of dollars more to reach that confidence level. So picking the right strategy would be really important for your patentability search.
So what's involved in that approach, and how do patent attorneys ensure that every possible piece of prior art is uncovered?
So that's a really interesting question. The universe that we're looking at isn't so limited that there's just like 100 data points there. And if you spend enough time, you can look at all 100. There's, over 12 million US patents issued. There's lots and lots, hundreds of thousands of published US patents. The universe is way too big to look at all of that. So it has to be a methodical strategy that's used and documented, so that one understands what was done with that and what type of results that you're getting. So you're getting like that 90-95% that's reasonable, that provokes the conversation of what are the differences and how can we capture your invention in the patent application, and how can we claim it in a reasonable manner, and avoid all of the prior art that is known. But with the unknowns, there is a chance that the patent examiner will find something that's more relevant, or that during litigation in the future, that a third party will put in 10 or 100 times the effort that we've put in, and we'll find that elusive piece of prior art. So again, it's a spectrum. And so, we try to move the needle in a reasonable manner to a place where we could find the relevant prior art and deal with it, but not be bound up that you're spending $100,000 on patent searching, for a patent effort that costs a fraction of that.
So let's wrap up today talking about why it's crucial to have a patent attorney or a professional patent searcher involved in this process. as opposed to relying on automated patent search tools or those general search engines?
Yeah, AI is definitely our friends. I use AI and I like it a lot. I was just talking with another patent attorney earlier this week, and he said he used AI to plan a trip, and he put in some information, and the response that he received gave him a whole bunch of data, and he went through it, and it basically gave him an itinerary where he was scheduled to have two dinners before he went and saw some entertainment later that evening. And he said, that's kind of frustrating because I don't need two dinners. His view was AI is a great tool when you're using it for something that you understand. It's not so great a tool when you're using it for a process that is unfamiliar to you, and the data that you receive, you may not be able to interpret and really use in a meaningful fashion. So two dinners might not be a bad thing for some people, but for a lot of us, we really don't need two dinners before we do other things.
Love that metaphor. Thank you so much for joining me today. This has been great.
Thank you, Abigail.
Thank you for joining us on Patent Options Podcast, Securing Intellectual Property Strategies with Jamie Sheridan. To connect with Jamie, visit www.sheridanlaw.com and please like, subscribe, and leave us a review on your favorite platform.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.